everybody. This is Gaston here for this week's Markman Minute. This week I wanted to talk to everybody about a case that I addressed in my Markman note, which we published on MimesisWebTV.com. And it's a case that I think is of interest to a lot of patent practitioners, but also investors. And it involves a company called Rovi. R-O-V-I is the ticker symbol. The event I wanted to address this week is a important patent case that they have against Netflix. Rovi is a large company, has a large portfolio of patents, many of which came out of the TV Guide. Rovi's in the business of enforcing its patents and signing licensing deals with content providers. Now, Netflix is obviously an important provider of online streaming entertainment, and Rovi has indicated that it wants Netflix to take a license to its patents. From the very beginning of the case, Netflix has actually taken a very aggressive approach. First, they filed a declaratory judgment action against Rovi, arguing that the patents are invalid and they don't infringe. And that case has been making its way through Judge Hamilton's court in Oakland, California. A couple of months ago, Netflix actually took an even more aggressive step. They filed a Rule 101 motion, or a Section 101 motion, which argues that the Rovi patents that are involved in the case should never have been granted. And the basis for this is the recent Supreme Court decision in Alice versus CLS Bank, where the Supreme Court addressed patent eligibility as it relates to business methods and software patents without expressly calling out whether or not software patents are eligible. The Supreme Court did set forth a restrictive test for determining whether or not a patent in this space is eligible. And district courts, since the Alice decision, have been very active in striking down patents. So it's unsurprising that Netflix has tried to short-circuit the case against Rovi by challenging the patents in this way. What's interesting about the hearing is that Netflix was successful in not only getting the judge to agree to hear the motion, but to actually treat it almost as a threshold issue in the case, which is obviously an incremental win for the defendant. If you can avoid the litigation costs and exposure by having this issue addressed early on, that could be very beneficial. So investors particularly investors in Rovi, are very interested in the outcome of this case. One, because Netflix is obviously an important target for Rovi's licensing efforts, and B, there's a sense that that the decision that the judge reaches with respect to these patents may be a bellwether for other patents in Rovi's portfolio. So I think it's so this is obviously a hotly anticipated decision. We don't know when the judge is going to release it, but it is indicative of the struggles that companies that are in the enforcement business, even companies that have been very successful in the past, like Rovi, who have hundreds, if not thousands, of patents to license to sophisticated counterparties, are facing in this era of the emboldened patent defendant. Between initiation of aggressive action in the patent office to try to invalidate patents, or as we saw Netflix do here with respect to a Section 101 Alice challenge, defendants in patent cases have been much more aggressive, and I think investors in Rovi are going to be very curious to see whether or not Netflix play is a successful one. That's it for this week. Catch us on MimesisWebTV.com. Thank you for listening. Catch you next week.